to the Dementia Care on Air podcast series. I'm your host, Anna Chodos, the Executive Director of Dementia Care Aware. The goal of this podcast series is to bring you short, educational moments that will help you detect dementia and care for people living with dementia. And we're especially focused on how we do that in the primary care environment in the real world. We're going to have a lot of information that mimics what we have on our website and in our other educational modules. But we're also going to have conversations with experts and other people in the community in the field of dementia care that just help us do a better job of caring for people living with dementia and connecting them and their care partners to the things they need. Very excited to welcome today Mr. Caleb Logan, who's a lawyer who works with Elder Law Advocacy in San Diego, for our topic on primary care's role in assessing decision-making in patients with dementia. Thank you so much for joining me, Mr. Logan, and welcome.
Yes, absolutely. I'm happy to be here. Thank you for having me. And just in general, I want to express my thanks to UCSF for going through all of this with the Dementia Care Aware program. And I'm a child of public schooling, so I'm just generally thankful for all that you do.
Well, having gotten to know you a tiny bit, I'm very grateful. You're clearly a person who really advocates for folks who need your help. So I'm so glad. And we need your help here in medicine and in primary care, trying to understand like what really is our role, how we support people, certainly in the context of dementia. This issue just comes up all the time. And I think it can be overwhelming. And what you really did in your webinar, which I encourage people to go back and watch or just look through your slides as well, is you really broke down like, what is the law around this? Kind of what should we know and what is our role? So I'm going to start with sort of the biggest and broadest question, which is in a sort of summary way and major points way, like how would you say you think about the clinician's role in supporting the person who may not have capacity and kind of what needs to happen around that as a lawyer, somebody helping people through this?
Well, in my line of work, I sometimes handle some nursing home abuse and neglect litigation. And so in that context specifically, it's really helpful to have a physician or, nurse practitioner, whatever it may be, their evaluation of how a patient is presenting cognitively. And that could be on a day-to-day basis. It could be on an appointment-to-appointment basis if they're spread across weeks, months, years. It doesn't totally matter, but the bottom line is that we're getting an actual picture of how the patient is progressing or maybe changing for the negative over time, so that then we are able to evaluate in the present whether they had capacity at a certain situation or not.
That's super helpful. So like we can sort of focus on the clinical aspects of their cognitive abilities in a moment of time and kind of help contextualize that for like bigger questions about, like, I'm guessing, what sort of decisions they made, what kind of situations they got themselves into, and if their cognition was really could have been able to support that, for example. Is that more or less correct?
Absolutely. Yeah. So the thing to take away here, I would say, is that the determination of whether someone has the capacity to do something or not isn't for us to make, not for a doctor to make, not for an attorney to make. It's actually up to a judge if a case ever gets filed in court about something. Maybe someone is challenging a will that possibly a patient made. And so the medical record can give us a picture of the evidence to argue one way or another for attorneys in court, but ultimately that's just a legal determination. And so the medical record is really just strengthening the argument one way or another, but it's not an actual legal determination in and of itself.
Great. Okay. So I am going to ask if like that's a sort of bigger idea of capacity. Like that's like a legal notion of capacity and capacity in a very broad, or maybe I would say even like global sense, versus one thing you really outlined super well in your webinar was just that there's different kinds of capacity, and that we should be aware of it because it sort of affects, I mean, it affects like practical decision making about how we're partnering with this person and how we're able to help them and their care move forward. Are you able to sort of go from the 30,000-foot view to a little more granular level on like these different types of capacity and what we should know about really like what that word is even really referring to?
Right, and that's a good question. I did actually hear, kind of following up from the last question, I heard recently that someone had been told that competency is a legal determination for lawyers, but capacity is something that's determined by physicians and other healthcare practitioners. That's not actually true. So long ago in the law, we had competency as a concept, and that was really an all or nothing standard. Since then, because that led to people often losing their rights when they had no reason to be stripped of them, as you say, we've moved to an issue specific standard with capacity. So, for example, in California, at least, we have different laws that say what level of capacity you need to make a contract. That would be often what's thought of as the highest level of capacity that someone needs. But then there are also other standards for making healthcare decisions. So that would come into play when someone's making an advanced healthcare directive, also called a healthcare power of attorney. And then the lowest standard actually would be the standard to make a will. And in fact, even when people are under conservatorships, they are still legally allowed to make a will. As long as they have that capacity, a judge would actually have to say, no, you don't have the ability to make that decision and take it away from them. So that's kind of how you can see, especially in the conservatorship context, actually, that the law goes from kind of a high level to a low level with contract to will. A conserved person can't make a contract, but they could make a will. So they're just different standards. And then each one, again, being issue specific, is tailored to the specific context. So many people might be aware of the informed consent standard. That's really focused on the patient's ability to understand the risks, benefits, alternatives to a certain medical treatment. And so the law is generally just guiding us to look at the specific factors present with a decision, whether it's healthcare, whether it's our property, for example, making a will, or anything else that might come up.
Okay, a lot there. So for the medical decision making part, we are taught that capacity is four things. And I think what's usually left out, I've noticed in some of our training in medicine, is it usually doesn't, it says like capacity is these things, but it's really should be a little more specific, saying medical decision making capacity is the following. And this was something you brought out in your webinar, that it should be time limited and specific to that moment when you're doing the assessment. But we basically learned that there's like four components that we need to assess to decide if that person has medical decision making capacity. And that would be, can they communicate a decision? Can they appreciate the information? Usually that is risks and benefits. Can they, are they essentially using a reason or rational thought process to get to a decision? And then, sorry, I think I skipped one. Can they understand the basic concepts? So they're sort of like, can they communicate at all about their choice? And of course, we should be trying to maximize their ability to communicate with whatever decision aids or hearing devices or whatever we need to do. But then do they understand the basic information? Like we're talking about a heart surgery, and the heart surgery is, means we're going to do these things. Then do they appreciate the specific risks and benefits themselves, that, their own person and their own situation? And then are they making a choice that seems based on reason? And that's like, are they not psychotic, or are they not, making a decision that seems to be heavily influenced by something that, isn't really making sense. Of course, not in a I wouldn't make that decision myself way, but just in a, as it like meet basic criteria for being rational. Sometimes I notice people, colleagues will struggle with, they don't seem to be able to manipulate certain kinds of information in a way that I can tell that they have capacity. And then they sort of extend that notion of lack of capacity to other things, like making decisions about discharge or making decisions about, how they, want to live their life in the community or something like that. And I think the other thing is we really struggle when people appear not to be making a decision that we think is in their best interest or seems to really have a good, be what we would do. That's when you start to have more friction around this issue. So, a very classic case is somebody who, has a very serious illness. We're strongly recommending hospitalization, and they don't want that treatment. But they can kind of repeat back all the information and just don't want to give you a lot of reasons, but do seem to be able to process information. Anyway, I think probably lawyers, you're not getting involved too often in that kind of really nitty gritty those medical moments, if you will. But I think with older adults with dementia, particularly, or, any age person with dementia, that starts to move that person to a place where they're having a legal proceeding that's going to start to take, their rights to make their decisions and transfer them to somebody else. So I just want to, having gone through that long spiel, I'm wondering if you have anything to add to the way we as medical folks, or I guess I'll just, maybe just me still, are thinking about medical decision-making capacity and what the law says about that. And then what's our role if that person is otherwise seeming to have a lot of challenges with decision-making in their life. And it's not, because definitely in primary care, it may not really be specific to a medical decision, and it may more be about day-to-day decisions that they seem to be really struggling with. And how and when should we be thinking about the legal interventions or legal supports that we could add to that situation?
Great question. I actually think that there's no time where those legal supports and interventions aren't needed, because especially in the context of making healthcare decisions, we never know what's going to happen. Not in a, I don't mean to be saying that in a doom and gloom sense, but realistically, we don't know what's going to come up in the future. And it's important that even if nothing happens in the future, that we've at least gone through these discussions, because it can help solidify what we want done for ourselves as we are perhaps losing capacity to do something. Maybe we do have an emergency situation in which those issues need to be known. And it's a good conversation to have with, especially with loving friends, family members, whoever it may be. So with that, I think you did a good job of tailoring capacity to the healthcare context. And the only thing I would really add is that, like you said, you're looking for the communication of a decision as to a specific item of healthcare. So maybe they don't quite understand the benefits, risks, and alternatives of a certain treatment, but they do understand the benefits, risks, and alternatives of being discharged. So they could have the capacity to make that discharge decision, but that doesn't mean that they had capacity to make whatever treatment decision came earlier. And from a doctor's perspective, obviously you have your own codes of ethics and institutional policies in place, so you need to be complying with those. But at the end of the day, people do have the ability to make their own decision. And even in the law, a lawyer has to do only what their client wants them to do. So we can't coerce someone to make a choice that they don't want to. And with that being said, it's easy for you to at least recommend options for patients coming in. So I see you don't have an advanced healthcare directive in your file. Have you thought about making one? Something like that. And if, like you posited, if that is extending to the more day-to-day decisions, you could ask, have you talked about a financial power of attorney? Maybe You might want to consider a supported decision-making agreement so that others that you trust can get involved and help you communicate what you want. And just raising those naturally in the conversation at any time, really, again, because these are these are documents that I believe at least we all should have in place regardless of our situation.
Yeah, so I really appreciate the way you frame that because the way I started talking about with patients is, you know, part of my job here is just to help you plan for the future, preventive measures for stuff that comes up, and having these documents and things done is just part of getting life done. It's and I really sort of remove it from some sort of medical doom and gloom scenario because that ends up being a clear reason we end up talking to patients about it a lot of the time is like clearly they're deteriorating or they've had a lot of hospitalizations or whatever it is. But here I try to get it done like way, way ahead of time when things are calm and things, they have time to visit free legal services in our area or whatever it is. And we have time to follow up on it if they, obviously it's a homework assignment. So sometimes people don't get it done. And the questions you use, I really like some of those. I may incorporate those. Like, have you thought about this? Oh, I always recommend it. And I do sometimes use the like, hey, any of us can get hit by a bus tomorrow kind of analogy, which is a little dramatic, but but like you said, it's true. Unfortunately, we don't know what the future holds. Um,
If I can add on, actually, I do think like you said, in times of lower stress, it's good to be thinking about these issues just because in times of higher stress, we actually probably have more impaired decision making. So, I mean, for example, I believe I shared out one of my presentations. My grandmother was having health issues, and my mom asked her what she wanted to eat. All my grandmother knew to say was, I want some of that white stuff. Because given all of the stress and the medical issues that she was having, she couldn't remember the word for yogurt. So it's times like those where if she were trying to make more comprehensive decisions about healthcare or what she wants in terms of end of life planning or other crisis planning, it would be a much more impaired decision. Now, whether that means she does or does not have capacity to do it is one thing, but the best situation that we can be in is one where we have the most calm, the most time to make a decision. That way, we're able to truly consider uh, all of the possibilities, all the risks, benefits, alternatives, and make a much more informed decision at the end of the day.
yeah, that's such an additional great point that like in a crisis, it's always the worst time to do everything is in a crisis. And especially if you're sick. How do you describe like the benefit of these sorts of documents and planning to like how does it fit in with capacity? I guess could you be like a little more explicit? Like either I guess if you're talking to a client or if you're educating somebody like myself.
I would say that the benefits are kind of like I mentioned earlier. So, one with actually processing it yourself, because sometimes these are decisions that we haven't thought of before. And so, just getting it out on paper beforehand helps us to form a more solid view on certain things like end of life treatment, artificial nutrition and hydration, things like that, that are often talked about. And the goal with capacity, as you went through the healthcare standard earlier, you're looking for the person to actually be able to communicate a decision. And these documents, whether it's a financial power of attorney, advanced healthcare directive, a will, a trust, they're all expressing your desires and actually putting them down on paper so that when the time comes, we don't need to ask what you want because we already know it's already been written down. And that is actually preserving your rights and your ability to make sure what you want to happen does actually happen. Because if it comes down to it, and let's say you have a medical emergency, you're in the hospital, and your partner doesn't know what you want because you haven't talked about it, then it's possible that you could be getting treatment that you don't want. And that's why, regardless of what happens, it's always good to have our wishes in writing so that we can make sure they're honored down the road.
Okay. So I'm going to do a couple of like summary points about some of the stuff we talked about, and then give you a couple scenarios and just have you give me a little advice. So we talked about the fact that there's sort of different types of the law sort of describes different types of capacity and different requirements and a different standard. So that was really interesting because certainly in medicine, we don't get exposed to that a lot. So, or clinical care. So someone to make a medical decision, it would be maybe a different standard than to decide to change their will or to sign a contract. And those, that is going to be decided in the moment by the person obviously charged with helping them with that thing. One quick question, because we get this all the time and it came up during our webinar time, was let's say I have somebody who does not really seem to have capacity based on my evaluation to make a medical decision and does not have any of this documentation done, does not have a clear surrogate, has some, family members and emergency contacts in the chart. I'm in the hospital or I'm in the clinic. What would be a, feasible next step? And would they have still capacity to tell me who they would want to make decisions for them?
It's a tricky question to answer, to be honest. So, if there is no document in place, but they do have the ability to name someone in terms of they understand who they're naming, they know why they're naming them, they are able to just nominate a surrogate, and that person will actually have authority to make healthcare decisions for them during the patient's stay or their treatment in the hospital. In no event, it can last longer than 60 days, so that is a hard deadline there. But if they are coming in and out, then maybe when one of the times they're on the up side of things, they could actually point to someone and say, you should listen to what they are telling you to do for me. Otherwise, it would really come down to who is around them. So next of kin, it's generally referred to as whether it's a spouse, adult child, a parent, an adult sibling, adult grandchild, just whoever is closest to them and actually is able to show some special care or concern for the person, then they would be able to make authoritative decisions for that patient. Otherwise, if there's no one there, then it would realistically come down to a referral to the public conservator in your county, and then they would make the decisions on whether proceeding with a conservatorship is needed. And always, following institutional policies, whatever guidelines they have in the situation. If there are any ethical rules that you need to follow, given like emergency care, that can always play a role, but that is how it generally would go.
Okay, awesome. And is that 60-day rule, is that a hospital thing or anything, like any scenario?
That's just when someone nominates a healthcare surrogate, as the law calls it. Not in a document like an advanced healthcare directive, but just pointing to, like, let's say I'm on the hospital bed and my mom is next to me. So I say she can make healthcare decisions for me. Then that would be recorded in my medical record, and she would have authority for that 60-day period unless I get discharged earlier.
I'm trying to imagine a scenario where it's like relevant to clinic, but let's say it is. Would it hold in an outpatient setting or no?
Likely not so much because it has to last for the duration of a stay. If that 60-day period isn't applying, the 60-day is kind of just if the stay is longer than 60 days, then it would expire. But for just a day-to-day appointment, it wouldn't apply very long in that setting just because of the more short-term nature of the appointment.
Okay, super helpful. Okay, so someone, let's say, is doesn't appear to have a good social network. They're kind of usually present alone or something like that to clinic visits and has not done any of this work ahead of time, is sort of able to give you some general sense of their wishes and, indicate a friend or something like that that they would want to make decisions for them, but maybe doesn't have the wherewithal to complete the documentation. But like we've documented that they've been consistent about naming this friend or, put them in this document. And then they do have a healthcare crisis. They have a fall or something and they're in the hospital and they're really not able to communicate. Is that something that's helpful to the treating team in terms, or like, could, let's say they need a rehab stay after their hospitalization, like is that person potentially able to serve as their advocate or their surrogate, like, going to a care facility?
Likely not in that setting, just because everything is limited by the duration of a particular stay. And I would say also that you want to be careful with people being designated for specific. So, I mean, kind of what this law is getting at with limiting it to a specific stay or treatment is that the person with capacity to name them might have some understanding of what's going on, but that would only be as to that treatment. So if they don't have understanding later on and they really are fully relying on this person that they name, they might not have even really understood that that the surrogate would be making those decisions. So that is kind of just the underlying assumption in the law, with it not applying across different settings. And I would also point out that whenever someone has capacity to make a decision, they are fully in control. So even if they are maybe relying on a healthcare surrogate in one instance because they don't have capacity, if they regain it at some point and disagree with what their surrogate said, they are in full control at that point as long as they understand, as we've talked about, the risks, benefits, alternatives, and all of that.
Great. So like even if somebody is, we're mostly relying or working with a surrogate to make decisions, but then they're kind of clinically improving, their cognition is improving, and we're able to we should be reassessing basically and making sure that we're still including that person. And we probably should be including them anyway, and never cutting them out. But it is true that I think you'll see sometimes like this person doesn't have capacity and then they sort of get written out of the process, frankly. So that is an awesome reminder. I really appreciate that. Okay, I gave you some hard ones, some really hard ones. But basically, I just want to, I guess we could end with someone, has a new and hopefully pretty early diagnosis, early in terms of early stage diagnosis of dementia. We want to sort of signpost for them that decision making may decline and that may become an issue for them. As you said, we should all have our paperwork done and we should all have our surrogates established. But how does like understanding their capacity, if you could possibly summarize such a big topic, how does understanding their capacity, even though they have dementia, how does that play into sort of just like routine care? And how are these, what would be like your top two recommendations about how to make sure that they're kind of taken care of in this area and have everything they need just in case they do end up losing their ability to make certain decisions?
Right. I wish I could give a one size fits all answer. I think really it comes down to just the fact that they it doesn't even necessarily need to involve their diagnosis because no medical diagnosis does determine whether someone has capacity to do something or not. So that's something that should always be kept in mind. But also, recognizing that capacity is a continuum and can come and go on different circumstances. Maybe their dementia is specifically bad at nighttime, like we hear with sundowners, all of that. You can really just walk them through their prognosis, especially. Say, this is what we typically see in people in your situation, making sure that they understand that, and really empowering them moving forward to be able to confront the circumstances when they come. Maybe it's possible that maybe they won't lose capacity at any time. Maybe the dementia isn't extremely serious, but if it is, then the bottom line is that you let them know that they could be in for difficult circumstances if they don't do the planning ahead of time. And again, reminding people that since it is a continuum, since it is fluid, since it depends on the specific situation and all of that, that whenever they are able to make their own decisions, they are in control. Nothing is taking that away from them other than their legal inability to make a specific decision. And realistically, we have all of these tools, including supported decision-making agreements, which were just started in, I believe, 2023, to avoid putting people under a conservatorship when realistically they don't need that. Maybe they have some issues with managing their finances, their health, whatever it may be, but the conservatorship is not actually the least restrictive alternative, and that's what it's meant to be. So at the end of the day, we're trying to preserve people's ability to make their own decisions, and whether that's through a document, whether it's through them saying it at a specific appointment or otherwise, that is the focus.
I think you handled it beautifully for me asking a terribly broad and hypothetical question when clearly that's all about the specifics. So that was awesome. You said the C word, so we're going to have to just quickly review why a conservatorship would happen, and then we will go out. And I will invite you back to explain to me what supported decision making really looks like for people with dementia, because you're right, that's pretty new. I would say I haven't seen it operational in practice, but it's super exciting, as you point out, from the perspective of like really making sure the person is at the center of the plan and the decision making. Okay, so take us out on why somebody would end up in a conservatorship and how that can actually be useful, and then we will end it there.
Sure, the conservatorship is really just playing out in court, and that's because a judge needs to actually rule on the evidence. Again, that could be medical records for everyone listening. So when it's actually allowed is when, again, it's the least restrictive alternative to help the person. But they need to specifically be, and you can kind of think of this in the same categories as like an advanced healthcare directive and a financial power of attorney. One is for the healthcare decisions, one is for finances. Similar with conservatorships, we have a conservatorship of the person and a conservatorship of the estate. So the person, that means the person can't provide for their own personal needs from things like physical health, food, clothing, maybe even shelter. And then the estate, when they're unable to manage their own finances, or perhaps they are extremely prone to fraud and undue influence, then that's a situation where the estate could come into play. Again, since it is supposed to be the least restrictive alternative, just fitting one of those categories does not mean you need to fit both. So you can have either a conservatorship of the person or of the estate. And then if you really need it, then both would apply. And there are some limitations to that. Like I said, even if someone is conserved, they are able to make a will if they have the decision-making capacity to do so. So, like a conservator, that's the person who has the conservatorship authority over the conservatee, who's the person being conserved. So, the conservator can't make a will for the person. They can't distribute their assets when they pass or anything like that. Similarly, a conservatorship of the person doesn't let anyone take control of who can visit the conservatee or anything like that, but they would be able to request, often in my situation at least, an elder abuse restraining order or other restraining order as proper.
Thank you. I do hope that for anybody who's listening, that conservatorships are hopefully something that they rarely have to help people muddle through. But really, really, really appreciate your time, and your expertise is so tremendous and so helpful. And I know you're out there helping to advocate for older folks and those with dementia all the time. So really appreciate it. Really appreciate your time, your expertise again. So thank you, Mr. Logan. Thanks for your time.
Absolutely. Thank you again for inviting me.
So for those who didn't see the webinar, really recommend you go check it out. A lot of this information is covered, including some of the particulars of the law that's in place. And on our website on dementiacareware.org, we have a whole page devoted to medical legal needs, and that has one-page explainers on all these issues like capacity, the different types of power of attorney, conservatorships, and how to avoid them, and how we can just better support our older adults and those with dementia in general. And another great part of the medical legal partnership was bringing together a lot of legal services for older adults, many of which are free and incredible and across the state. So elder law and advocacy is one of those, but definitely recommend that you take a look and see what's available in your county and reach out to the network. Thank you for listening and to our wonderful guests. And thank you to Lisa Costello, our audio editor and voice specialist. We want to make sure you know you can get CE, CME, and MOC credits by going to our website, clicking through to the podcast page, and answering a quick quiz to claim credit. This is all possible through support from the California Department of Healthcare Services and the hard work of our Dementia Care Aware team. If you want to learn more, please visit our website, dementiacareaware.org.